And again, good afternoon, everyone. Thanks for joining me here today. As Alex said, I'm here to speak about, as you can see on your screen as well, the key WSIB and COVID-19 developments for staffing firms. So I want to really primarily speak about two issues today. First of all, I want to just discuss the new WSIB Rate Framework that came into effect this year, but really starts getting important for staffing firms next year, starting at the beginning of 2021. Then I also want to talk a little bit about how COVID-19 claims are adjudicated by the WSIB, during this pandemic that we're dealing with. So as Alex said, I'm a lawyer at Williams HR Law. I practice in all areas of labor and employment law, including significant WSIB practice. It's a significant part of my practice that I do perform that's a bit unusual in labor and employment law. It's a bit of a unique world, but it's one that myself and others at my firm do have a great grasp of. So again, I want to provide really primarily two pieces of information: the new rate framework and how it applies to staffing firms or temporary employment agencies, as the WSIB refers to them, and then also the WSIB's broader approach to COVID-19 claims right now. Okay, now in order to go through that, I'm going to start off. I'll provide a bit of an overview of the entire WSIB scheme. I think that'll be helpful to make sure we can level set for everybody who's going to be attending here with us this afternoon to make sure we're all on the same page. Then I'm going to shift in and discuss about the new rate framework broadly, as well as the specific WSIB approach through that new rate framework to staffing firms, before ending with the WSIB's approach to COVID-19 claims right now. I should say anytime throughout the presentation, if you have a question, please do ask any questions that you have in the section of the presentation. It should be on the right of your screen if your screen looks like mine. And please do ask those questions. Often, if you have a question, others may have questions as well, and therefore I'm more than happy to try to contend with those as we go through here today. So first of all, again, I want to just provide the broader overview of the WSIB scheme. And so you'll see there are 3 points that I want to speak about: what the WSIB is, how WSIB benefits work, and how WSIB claims specifically work. So first of all, with respect to what the WSIB is, I'm sure that everyone, if you're attending this presentation, you know, but again, just to level set, it's mandatory insurance coverage. Workplace Safety and Insurance Board is what it stands for, and it's mandatory workers' compensation insurance coverage for most employers in Ontario. Not all employers, but most, and including all staffing firms. Staffing firms do have mandatory coverage in the system, and so I'm sure those attending here today are aware that you do have to pay into that system. And so how the system works very broadly, it's not all that different from other insurance schemes, although certainly there are very tricky intricacies that you need to be aware of. But generally, as an employer, part of this plan, you pay premiums based on the amount of wages that you pay to your employees into the WSIB, and then the WSIB will pay out costs and pay for healthcare and different types of costs for employees of yours that are injured while they're working. And so generally the premiums are based on a certain dollar amount in relation to each $100 of wages that you pay out. So, depending on the premium rate that you're falling within, it might be $2 or $3 per every $100 of wages that you pay as premiums to the WSIB. And, $2 per $100, for example, essentially that means you pay a premium of 2% of the wages that you pay to your employees to the WSIB. And the intention of these premiums, what those are for, is to fund the WSIB's ability to pay for employee premiums. Employee claims costs when your employees are injured while working for you. Generally how it works, and I'm going to oversimplify a little bit just to get us all on the same page, to determine the premium rate that applies to a certain employer, the premium rate is set based on the broader industry class, and then the premium rate can go up or it can go down depending on the employer's individual claims history. Generally how it works is if you have more claims or more claims costs, the WSIB pays out more to your employees because of their injuries than average for your industry, you're going to pay more than the general premium rate. And if you have a better claims history, so fewer injuries, lower costs for the WSIB than average, you'll pay less than the regular premium rate for your industry. Now, WSIB benefits, there's a number of different types of benefits the WSIB pays out. Generally, they're either monetary or different forms of support. So from a monetary perspective, the WSIB will pay loss of earnings, or LOE, benefits when an employee is injured and can't work for a period of time because of that workplace injury. So if the claim is approved, the WSIB agrees they were injured at work and they can't work because of their injury, WSIB will pay loss of earnings benefits to them to replace most, but not quite all, of their income that they're missing out on because they can't work due to the injury. In addition to that, the WSIB will also pay what we call a NEL, non-economic loss, when an employee is injured at work and WSIB determines they're never going to fully recover from that injury. So once they get to the maximum recovery that they're going to get to, and that's not all the way back to how they were pre-injury, the WSIB will pay a one-time lump sum NEL, non-economic loss payment to that employee to help essentially compensate them for the ability that they lost through that injury. Separate from the monetary supports the WSIB can provide directly to employees, they also provide other types of support that certainly cost the WSIB money and therefore can indirectly cost you money as employers by increasing your premiums, but don't actually provide money directly into the pockets of employees who are injured. And the different types of support that we see are healthcare supports. So depending on the injury, there might be rehabilitation costs, physio, psychology or psychiatry, different medical devices, medications, whatever the case may be that the employee needs that the WSIB can provide to them to help them recover and get better from their injury. In some other cases, the WSIB will actually pay for education. Usually that will happen where an employee gets hurt at work and they're never going to be able to return to their same job due to their injuries. In those cases, the WSIB will, in some cases, actually pay for them to be retrained in another industry or quite commonly in language training. So oftentimes the WSIB will actually pay for an employee to get English language training if they don't speak English very well to help them get a job in another different industry after they're injured and can't continue in their existing industry. Now, who's eligible for WSIB benefits? Generally, it's workers who suffer a work-related injury. And the test that the WSIB follows to determine that is generally where the injury arises out of and in the course of the employee's employment, the claim will be approved. So really what that means is that if a worker is working at the time that they're hurt and they get hurt in some way related to the way they're working, as opposed to doing something completely for personal reasons while working, if the injury arises out of their work, then they're going to be approved for WSIB benefits. And then again, the amount of benefits depend on the severity of the injury, whether they have to miss work, how many different types of healthcare they may need to recover, etc. And how do claims work? Really briefly, claims work through the Form 6, Form 7, and Form 8, which some of you may be aware of. So these are the forms that have to be submitted to the WSIB when an employee suffers a work-related injury. The Form 6 is the employee's responsibility. As an employer, you're expected to help them fill out the Form 6 and understand to submit that to the WSIB. That's part of your obligation, but it's the worker who actually has to complete that and submit it. The Form 7 is your obligation as the employer. So you have to complete the Form 7 and submit it to the WSIB to tell them about the injury. And the Form 8 is for the employee to go to their doctor and then the doctor to submit to the WSIB about the medical nature of the injury, which of course impacts what types of benefits need to be provided by the WSIB. The Form 7 is the first most important step, and I speak to so many different employers that misunderstand this and set themselves back right from the beginning of a claim. If you have some sort of doubt about an employee's injury, whether they actually suffered the injury in the first place or whether if they did suffer it, if it was actually suffered through their work, arising out of or in the course of their work or not, or if you have doubts about the severity of the injury, if you think that they're milking it, or if you think that they're trying to get more benefits than they really need and they are able to work even though they're saying they can't, the Form 7 is your first best chance to let the WSIB know. So if you have certain doubts because of the way that it was reported to you or when it happened or what have you, you put that into Form 7 or in an additional document you attach with the Form 7, because that's how the WSIB will adjudicate it right from the beginning. And they'll determine whether there is a compensable injury or not from the start. And once the WSIB approves, yes, there is an injury, it's much harder to get them to reconsider that and change their mind about whether there was an injury that was related to the workplace in the first place. So that's WSIB generally. I don't want to spend any more time. I only have 20 minutes here and we're really about halfway through, but I'm hopeful that'll really give you all a good baseline understanding of the system that we need to be concerned with here. So now I want to speak about the new rate framework that's come into place this year, January 1st of 2020. Essentially, the way that WSIB works, before this new rate framework, there were hundreds of different minute classifications, and each of those had a different premium rate that employers would have to pay depending on the work that the employee performs and the level of risk associated with that work. Generally, the riskier the work, the more likely it is that an employee is injured, the more costly the premium rate will be to compensate for the additional expected costs that WSIB will have to incur in relation to employee injuries. So that was the old system. There were hundreds of them. It was quite complicated. They've simplified it somewhat now. And so now there are only 34 different classes and subclasses that each have their own, we'll call it a baseline premium rate that applies for the work that the employee is doing. So there are far fewer. It's a bit of a simpler system than it used to be, which is particularly beneficial for temporary employment agencies, as they're called by the WSIB, staffing firms, because you, unlike most employers, may well have employees in a number of different WSIB classifications. So again, each of those 34 classes or subclasses has what the WSIB calls a class average premium rate. We'll call that the baseline premium rate. And then the premium rate will either go up or go down depending on your claims history, as I was saying before. Specifically, how it works in this new system is that employers will be placed into a certain risk band. So basically, you'll have a little bit higher risk or a little bit lower risk than the average, depending on your claims history. And you'll be placed into a risk band based on your level of risk, which again is based on your claims history. So if you are very, very risky, if you have a lot of employee injuries in the past, more than average, then you're going to be placed in a higher risk band with a higher premium rate. Your premium is going to be adjusted up quite a bit more than it would be for others in your industry who aren't who don't have as many injuries. And the converse is of course true as well. If your premium rate is lower, it's going to be because your employees tend to get fewer injuries and there are lower costs that the WSIB has to pay out because of your employees' injuries than average. I'm not going to spend any more time on the risk bands here just because it does get a bit complicated. Suffice to say that there are some certain transition rules in place right now where employers will only have their premium rates increase above the class average premium rate by a certain amount each year at the beginning for these first couple of years until about 2023, when premium rates can go up by as much as 15% in any given year. So I mentioned at the outset here, there are special rules for temporary employment agencies, as they're termed by the WSIB. And so these rules, in short, provide that temporary employment agencies have more work on their hands to ensure that you comply with the WSIB's rules than most other employers because of the nature of the work that you perform. And so generally, most employers will have only one premium rate. That'll be all of their employees will be set within whatever is the predominant class that they perform for the industry that they work within. So even if they have workers doing different types of work in different industries, whatever the majority or the predominant one will be, generally that will be the class for all of the employees, and the premium rate for that class will be the same for all of the employees. For temporary employment agencies, it's quite a bit different from that general rule. How it works for staffing firms, or again, temporary employment agencies, is that you're going to have different premium rates depending on the work that your employees are performing. So there's one premium rate that will apply, one class and one premium rate that will apply for those employees that you have who are actually involved with the business practice of supplying workers to your client employers, so the clients to perform the different types of work that your clients do. That's one premium rate. But then you'll also pay different premium rates depending on the type of work that your temporary employees perform for your clients. So let's say you have clients that work in a number of different industries, and those cover 10 different classifications under the WSIB's 34 classifications. Then generally you're going to be expected to pay premiums within each of those 10 different classifications. So you'll have 10 different premium rates that you need to worry about paying depending on the work that your employees are going to perform at any given point for your different clients. Now, I hope that's clear. Again, to be very, very clear about this, your employees, your temporary employees who are performing work for clients in certain industries, whatever the classification that applies to that work, to that client's business is, that's going to be the classification that you need to be concerned with for those workers when they're performing that work. And the premium rate that applies to that is is going to be the premium rate that you pay for those workers' wages when they're performing work for those clients. Now, another really important thing to keep in mind is that temporary employment agencies are required to maintain segregated wage and payroll records for each classification that their workers are working within. So again, back to my example, you have 10 different classifications that you have workers working within because of all of your different clients, industries. You need to have segregated wage and payroll records for each of those 10 for the purposes of reporting to the WSIB accurately. And why this is so important is if you don't do that as an employer, as a temporary employment agency, if you don't properly segregate your payroll and wage records, then the WSIB is going to essentially require you to pay the highest premium rate of any of the different classifications that you have workers performing work within for all of your employees, no matter what work they're actually performing. So, to give you a really extreme example, let's say you have 100 temporary employees, 99 are at a very low risk employer that have low premium rates associated with that work, and one performs very risky work for a client that has a higher risk business and therefore a much higher premium rate. Well, if you don't properly segregate the payroll records between all those different employees, the one doing the riskier work and then the other 99, then the WSIB is going to require you to pay that much higher premium rate that applies for the riskier business that that one employee performs. You'll have to pay that higher premium rate for all 100 employees that we're talking about. And so that's why it's so important to really properly segregate those wage and payroll records. And it's important to note that the specific rules around segregating those records are pretty complicated and they're pretty technical from the WSIB. So if that's not something that's on your radar right now, that's something you should look into as promptly as possible and try to get that remedied, because if the WSIB does an audit or for whatever reason finds out that you're not doing things properly, your costs can skyrocket, especially if you have a lot of employees performing some riskier work. Now, those rules that I just spoke about, again, within this new rate framework, those are going to really kick in next year. So for all the other employers, the new rules started this year. For you, certain new rules started this year, but the rules I just explained are the go forward starting January 1st, 2021. For 2020, for this year that we're in right now, you're going to have a net premium rate based on your claims history, but it's going to be one premium rate based on your broader claims history leading up to this year. And then you're going to pay to the WSIB the lesser of that rate or the applicable rate for the work that your employee is performing for this year. So to give you an example, let's say you have, again, one employee performing really risky work at a very high premium rate, but your net average premium rate from all of your claims history up to this year is much lower than the premium rate that applies to that really risky work that your one employee performs for a client. Well, you're going to be able to pay the much lower rate, that net premium rate from your own history for this year in relation to that employee, even though they're doing that riskier work for your client that would otherwise have a higher premium rate. But that's this year only. Starting in January 1st, you're going to be paying that much higher premium rate for that employee doing the riskier work. And all of your employees, you'll be paying whatever the premium rate is for the work they're performing. Now, again, if you're not sure if you're doing this properly, I would recommend you do get some assistance with that and make sure you're doing it properly. And I would caution you, if you're planning to call the WSIB, I've seen many employers get themselves in trouble where they call the WSIB and let the WSIB know, here's what I've been doing. Am I doing this right or not? And it turns out they've been doing it wrong, and you've just essentially outed yourself. You've put yourself on the WSIB's radar and cost yourself a lot. So there are sometimes other ways of dealing with that where you fix things internally and start reporting properly going forward, and the WSIB may never find out that you were doing it wrong before, and you may be able to save yourself. In some cases, I've been able to help clients save tens of thousands of dollars in cases like that, where they fix things and get improved going forward. So I know I've come to the end of my time here. I'm going to very quickly just speak to the COVID claims. This will just take me about a minute. Essentially, how COVID claims work is if the WSIB believes that an employee has contracted COVID-19 through their work or while they're working, they will be approved for a WSIB claim for the COVID-19 that they've contracted, as long as the employee has some sort of symptoms. If they're asymptomatic completely, they won't get approved. They won't get any WSIB benefits, even if they have to quarantine out of precaution because they have COVID-19. But if they have any symptoms at all, and the WSIB agrees that they did contract COVID-19 at work, then that claim will be approved and they can get WSIB benefits just like they do for any other types of injuries, including loss of earnings benefits, like I said, healthcare benefits, whatever the case may be. Generally, how the WSIB will determine whether they contracted COVID-19 at work, because obviously we can't say with certainty where you catch a virus that's going around all over the society. The WSIB will look at the nature of the work and look at whether the nature of the work actually creates a higher risk of contracting COVID-19, whether that's because they're in close proximity to other workers or what have you. And then they'll look at whether the COVID-19 diagnosis has actually been confirmed. So if there's proof that the individual has contracted COVID-19 and the type of work that they're performing makes it more likely they're going to get COVID-19, it's likely that the WSIB will approve a claim for WSIB benefits for that worker where they do suffer some sort of COVID-19 related symptoms. Obviously, this one is so important right now because today, for those of you who have seen it, we had 1,575 cases in Ontario alone, which is by far a record to this point. And I saw something today saying that they're anticipating that we may have more than 2,000 cases per day by the beginning of December. So the numbers are still going up pretty significantly right now. And so you can expect to see more COVID cases arising out of those who are performing work in workplaces right now. So that takes me through my whirlwind presentation here. One thing I did want to just put on your radar, if you have more questions about COVID-19, if you're not sure how everything works, my firm, Williams HR Law, we do maintain a COVID-19 resource center, which you can link to from our website, williamshrlaw.com. That has lots of different resources for you, articles, videos, FAQs, different types of information that you can leverage to ensure that you understand how all the different laws work right now in the context of this pandemic we're dealing with. Okay. So thank you all so much for attending. I truly appreciate you all joining me here this afternoon. And of course, thank you to Toronto Jobs and thank you to Alex for putting us on here. And thanks for having me here to speak to the group. I hope you all got something valuable here today.